I'm so I'm so happy to be here to kind of share some of the information in this new law. This is really kind of fresh coming out from August 23rd. And so I wanted to kind of go through some of the definitions in the new law that might help guide our clinical practice. But first, before we kind of get started on the presentation, quick disclaimer, I am an MD, I am not a JD. I do not perform any kind of law, and this is really my kind of interpretation of the law, and again, pulling out definitions that are present in it. Next slide. So pre-Dobbs, we're talking, 2019, 2020. Here in South Carolina, we had a 21 and 6 gestational age limit for abortion care. Abortion care is not covered by state insurance or Medicaid. And while 21 and 6 to some might seem like a very long time, a far gestational age limit, functionally, we didn't really have a 21 and 6 limit for most patients who are getting abortion services at clinics. Because we only have 3 clinics in the state that provide services, and all of them are at or less than 14 weeks of gestation. So if you were a patient who has a positive pregnancy test, desires termination, really you'd be looking at navigating care in South Carolina at or under 14 weeks. 21 and 6 was really only available for patients who are undergoing second trimester care in a hospital setting. There were restrictions on private offices. So any office that exceeded 5 abortions in any month or any second trimester abortions needs to register as an abortion clinic and then be subject to trap laws, which are as complex as the width of door frames in your office. We had mandatory education and a 24-hour waiting period with a written attestation that's known as the Women's Right to Know. And there's a mandatory reporting form to DHEC. Next slide. As far as methods of abortion, we have medication methods. This includes mifepristone, which is a progesterone receptor antagonist, and misoprostol alone methods, and then second trimester induction, which again would be hospital-based. For procedural abortion, there's uterine aspiration or DNC that's performed in the first trimester, and D&E for the second trimester. I also want to make a note that this has been going on in South Carolina for a while, but we're probably going to see more of it, and that is self-managed abortion. So these are patients who are undergoing medication abortion, but they're obtaining these pharmaceuticals outside of typical medical care like clinics or doctor's office. These days, mostly people are using online forums such as Aid Access or Plan C to obtain these medications and then have them shipped to their home or a PO box. Next slide. Regarding complications of abortion, this has been studied very extensively by the national academies. So in the US, while we've had legal and accessible abortion care, abortion has been very, very safe. We're talking rates of complication less than a wisdom tooth removal, less than a colonoscopy. So majority of women who obtain abortions in the US are less than 13 weeks pregnant. Majority have 0 complications. Some, we're talking less than 1%, have a complication that might require an additional surgical procedure or hospitalization. And those complications are typically bleeding, such as a post-abortal hemorrhage, infection, and retained products, which might require a re-aspiration procedure. For early medication abortions, we're talking those first 9 weeks of pregnancy, risk of serious complication is even less. It's quoted as actually being like 0.3%. Next slide. These are the sites of the 3 abortion clinics in South Carolina. So there's a Planned Parenthood in Charleston, a Planned Parenthood in Columbia, and a privately owned clinic, the Greenville Women's Clinic in Greenville. Next slide. So I pulled the data from DHEC. Again, I think it's important to know where we've come from, to know where we're going. So for our data from 2021, note that in South Carolina, there were 6,000 abortion procedures. Of those, almost all were first trimester, again, accessed through these 3 clinic sites. There was a sprinkle. We're talking 50 second trimester abortions that were performed in the state. And those are typically performed for fetal anomalies, for maternal health conditions, which are exceptions to our current law. Next slide. By method, for our 2022 data, we had a total of 7,000 abortions, and 5,000 of those were performed with medication. Again, that is a first trimester abortion, and is very, very safe. The number of procedural abortions were much less, again, approximately 2,000. Next slide. And this data is actually data that was pulled by DHEC from for the South Carolina Senate. And in this data, we're looking at abortions that were performed for South Carolina residents out of state versus in South Carolina, and how many abortions in South Carolina occurred for out of state women. I know that sounds a little bit confusing, but there was the legislature was concerned that South Carolina was becoming an abortion destination state. I'm sure you all read that in the news or read it in the paper. But if you look at the numbers here, again, 2021, your total abortion occurrence in South Carolina was 6,200 women. The number of abortions for South Carolina residents that were out of state was 6,500. So we already know that as many South Carolina women who get care in South Carolina are getting it out of state. In neighboring states like Florida, North Carolina, Virginia, there's a lot of out of state transfers going. And then the out of state women who were getting care in South Carolina, again, understandably had an increase between 2021 and 2022 because we saw 6-week bans occurring in neighboring states such as Tennessee, which has actually a complete ban, Kentucky, Georgia is a 6-week, and really all along the Southeast from Texas over. So this again was not a big surprise that we would have more abortions occurring, but again, majority are very early, majority are medication. Next slide. So in 2021, we had our first heartbeat ban that was enacted. This banned abortion after fetal cardiac activity, had exceptions for rape, incest, anomalies, and maternal medical emergency up to 20 weeks post-conception, or essentially 21 and 6. It was signed in February 2021, but was enjoined, and so really only was briefly enacted after the Dobbs decision. And this is the one that went up to our Supreme Court as of January 2023, was deemed unconstitutional in a 3-2 vote with Justice Cahern as a majority opinion. And as most of you know, she had a mandatory retirement at the end of this term, and she was replaced by a male judge. She stated that a 6-week ban infringes on a right of privacy and bodily autonomy. Next slide. The 2023 Fetal Heartbeat and Protection from Abortion Act is the law we have enacted currently. So this one was passed through special legislative session throughout the spring and was signed into law May 25th. It makes abortion illegal after detection of a fetal heartbeat, and it creates criminal consequences and fines for providers. However, patients are protected. They have delineated 4 exceptions, which we'll go through individually, for rape and incest up to 12 weeks gestational age, fatal fetal anomaly, and maternal medical emergency. This was initially enjoined after it was signed. It went to the Supreme Court, and as we know, it was deemed constitutional on August 23rd. The South Carolina Constitution prohibits unreasonable invasions of privacy, and so our new panel of judges felt that this was a reasonable policy decision and that the individual's right of privacy did not outweigh the interest of the unborn. Next slide. So the crux of these heartbeat bill bans is that it requires ultrasound as part of the decision-making and kind of eligibility for abortion. So ultrasounds must be performed greater than 60 minutes prior to procedure or medication administration. It can be transvaginal or transabdominal. The provider who's performing the ultrasound must be physically present in the same room with the patient as another way to kind of eliminate telehealth access. The provider must review the risks of undergoing or not undergoing the procedure so the patient can make a knowing and willful decision. You're required to obtain a gestational age via ultrasound. And then you are to request of the patient whether she wants to view live ultrasound images, hear the unborn child's fetal heartbeat, and explain to her what the findings are. As far as from a physician side of things, we have to document that the patient was given a form telling her of her due date, that her pregnancy has a fetal heartbeat if present. You have to inform the patient about the probability of bringing a fetus with a heartbeat to term, with all the best statistical probability information that we all have. Next slide. You have to provide attestation statements to the patient, which you must sign with her. This is information about fetal development, agencies which offer alternatives to abortion, and medical assistance benefits. And they have to sign that they have been given the opportunity to view their ultrasound image. It is unclear whether this attestation is only one attestation at the time of the ultrasound, or whether at the time of abortion they have to sign a second time another attestation that they have received all this information. And that is very ambiguous in the law. Next slide. Contraceptives, another very important definition that was in this 2023 fetal heartbeat law. A contraceptive is defined as a chemical that prevents ovulation, conception, or implantation. So in my evaluation of this definition, our oral emergency contraceptives such as Plan B and Ella really work by preventing ovulation. The implantation addition into this definition would make you able to provide a copper IUD, even though it might have a post-conception but pre-implantation effect as emergency contraception. It also requires that individual and group health insurances must include coverage for contraceptives, and then the state health plan has to cover prescribed contraceptives for dependents. Next slide. Another interesting definition that came out of this law was the idea of child support starting during pregnancy, and interestingly, starting on the date of conception, which most of us know conception is not, like fertilization is not a firm date or time, and is really impossible to know. But it does support getting child support payments during the pregnancy, as well as 50% of the mother's pregnancy expenses. If paternity is unsure or contested, you can get child support retroactively with accrued interest on that child support if not paid during the pregnancy. If there is rape or incest, the biological father would be also responsible for the full cost of any mental health counseling for the patient. Next slide. As far as physician consequences, so this would be consequences for performing an abortion when there is a pregnancy with notable fetal cardiac activity. It really is criminal. So you will be guilty of a felony, fined $10,000, imprisoned for not more than 2 years, or potentially both. There's also licensing consequences. So if you are guilty of this felony of providing abortion with fetal cardiac activity, your license will be immediately revoked by the State Board of Medical Examiners. And also interesting is this complaint to the board can be originated by any person or by the board. Next slide. There are also listed lay person consequences. So if someone is providing, again, maybe self-managed abortion options for patients, or is providing abortion outside of the medical community as a non-licensed provider. They would also be guilty of a felony and then would be imprisoned for 2 to 5 years, but only fined $5,000. And again, they do delineate again that there would not be consequences for the patient herself. Next slide. I think the best definition we have is for medical judgment. So this medical judgment definition could potentially be protective for OBGYNs in our state, providing gold standard medical care that's accepted on a national level by FACOG, our national organization, and SMFM. So reasonable medical judgment means that would be made by a reasonably prudent physician who is knowledgeable and understands treatment possibilities of the medical conditions involved. Next slide. They define medical emergency as a condition that could cause death or substantial and irreversible physical impairment of a major bodily function. They do exclude any psychological or emotional conditions, as well as threats of suicide. Next slide. They even went so far as to define what these some of these medical emergencies might be, including molar pregnancy, partial mole, ectopic pregnancies, preeclampsia, HELP, placental abruption, physical maternal trauma, uterine rupture, and then all types of miscarriage and IUFD. They did say that physicians should make all reasonable efforts to deliver and save the life of an unborn child to the extent that it does not adversely affect the life or physical health of the pregnant woman and in a manner that's consistent with reasonable medical practice. Next slide. Fatal fetal anomaly, they define as a profound and irremediable congenital or chromosomal anomaly that with or without the provision of life-preserving treatment would be incompatible with sustaining life after birth. As a physician, you would have to document the presence of a fatal fetal anomaly, the nature of that anomaly, and the medical rationale for making the determination that with or without life-preserving treatment, life after birth would be unsustainable. Rape and incest clauses, again, this is the extension really up to a 12-week gestational age for these patients. You are required to contact the sheriff in the county in which the abortion was performed within 24 hours. You have to notify the pregnant woman that you will be reporting this to the sheriff, and you have to provide not just her name, but her contact information. Next slide. So what does this really all mean? It means that looking at our abortion ban landscape today, really all of the Southeast has significant restrictions. This means that patients who are in Mississippi and Alabama, instead of coming to South Carolina, are now going to Virginia, DC, Maryland. It also means that now our patients are going up to Virginia, DC, and Maryland for care. Next slide. So regarding reasonable medical judgment, again, I think we should really consider this to be a way to be protective when we're taking care of women in dire situations. You can always speak to perinatal referral networks to get MFM consultation or feedback. In our institution, we are doing a 2-physician sign-off essentially for any fetal anomaly or medical emergency as a way to be protective, even though that's not in the law itself. I would recommend everyone become acquainted with hospital legal and risk management. We've developed EMR dot phrases for law exceptions. That way everyone is using uniform documentation. And again, this is a risk of a felony. So talking with your legal team about having a criminal defense attorney available. We may see more and more self-managed abortion patients, both in the emergency room as well as physician offices. The closest accessible care for our patients is North Carolina with a 12-week ban and Florida with a 15-week ban. The closest second trimester care would be Virginia, which would be hospital-based. They have clinic availability up to 15 weeks, and then afterwards, it would be hospital-based. In DC and Maryland, there are both hospital or clinic-based options for second trimester care. So as you all know, when we have our chromosomal anomalies, when we have fetal anatomic abnormalities, those are really being diagnosed in the second trimester. So we'd be looking again at sending those patients out of state. So I know that was a lot of just the law itself